So I did promise that we'll finish on time, and we will. So I'm just going to whip through our last little segment here, which is just drawing the threads together, particularly of the legal discussion. And I'll get through this in about 60 seconds. Hopefully we'll have time for a question or two and close the formal proceedings. But James and we will be happy to stay around afterwards for some informal discussion as well. So what we're giving you here is our top 10 tips that we've pulled out of the session. And we've actually produced a one-pager which is in your packs, which has got these top 10 for you to take away with you as well. So the first point, and both your internal marketing people and also make sure that your external agency knows these points as well. Set the ground rules for consumers through, for example, your house rules on Facebook. And Coca-Cola is a good example of setting those ground rules in a very clear and useful way. Then we say, obviously, monitor your social media accounts regularly, all the time. It's somebody's job. It's not something that somebody does when they get around to it or if they happen to have time. Be particularly aware of crisis time and the need to swing into action and be aware of what's happening on social media and respond to it. Obviously, meet socially acceptable standards, consumer posts as well as your own posts. Anything that's potentially misleading, take it down or possibly correct it. If it's defamatory, probably just take it down. On the other hand, don't remove a post just because it's critical of you. Respond, try to build credibility. We talked about regramming and republishing content without permission, copyright risks in particular. Do use the technical features, for example, on Facebook, that you can use to reduce your risk. So you can blacklist not only swear words, but other perhaps inappropriate words that you don't want to see on your page. Particularly difficult users, you can blacklist as well. And of course, you can put an age gate, as say the alcohol companies do on their Facebook pages. Know what types of promotions are and aren't allowed on the social media platforms and follow those platform rules. So that's, again, one of the pages that you've got in your little packs there where we've boiled those rules down for you. Of course, if it's a game of chance that you're running as a competition, you need to get permits as well in Australia. And then finally, as I said earlier, make sure that you disclose any commercial relationships with influencers. So we've just got maybe time for one or two questions and then we'll wrap up the proceedings. So, yeah.
I was wondering if there's a legal difference between hiding a comment versus deleting a comment?
Is there a legal difference between hiding a comment and deleting it? No, not really. I think it achieves the same purpose. So as long as you're sort of taking it out of a public realm, if you're hiding it, then that's probably just as good. Who you're hiding it from, I suppose, is the question. Who can still see it?
So their friends, the people that they're in there.
Yeah. So I suppose there is still a risk to the extent that other people can still see it. It could still be the basis of a defamation action or something like that. But obviously, it would reduce your risk in a practical sense by quite a lot, I would think.
I guess you could say you have taken action.
Yeah, you've taken action, and so the harm that anyone suffers will be reduced because not as many people are seeing it, and the risk of anyone finding out that there's been a copyright infringement or defamation or whatever it is probably much lower because less people are seeing it. Yeah.
I just want to confirm a comment in relation to competition and the photograph. The presenter stated that images would be protected by Privacy Act as personal information.
Yes. Yeah, so the question is around the Privacy Act and personal information. So the Privacy Act is all about protecting personal information of individuals. The Privacy Commissioner has said very clearly that a photo of you is personal information about you. So the fact that I was standing there with Alison and Kerry on that particular day and wearing a funny shirt, that's personal information about me, and people who know me could identify me from that photo. So in that particular case, the company that's running the competition, GHDAD in the example, is collecting personal information because they're collecting all the entries and looking at them. So they are collecting personal information. That means they need to do all the right things from the Privacy Act point of view. They need to have a privacy policy, they need to be giving privacy statements which we would build into the terms and conditions of competition to say this is what we're doing, we're collecting images, this is what we're going to use them for, we won't be disclosing them to anyone else, all that sort of thing. I might just take one more right from down the back there and then we'll close proceedings.
Do you have a duty of care if you're dealing with high-risk people about comments that they might post on your page?
Yeah, do you have a duty of care about high-risk people, about comments that they might post? So the duty of care, that's an idea out of negligence law. Do you have a duty of care? Could people suffer harm because you're not doing enough to take those difficult people out of the equation and maybe block them from your Facebook page or whatever it might be? I think it's a bit of a stretch. I'm not quite sure that negligence law would come into it. The issue is probably more, say, in copyright law, you have the idea of authorising. So if you authorise a copyright infringement, then you also breach the Copyright Act. So if you're the brand owner, you might be in danger of authorising. If you know that there are particular people out there who continually put up copyright infringing material and you don't do anything about it, then perhaps you're getting into that realm of authorising or sanctioning, approving. I think that's probably the way to look at it. Similarly, from the misleading and deceptive point of view under the Australian consumer law, it's probably not so much a duty of care, but if you know that someone's published something misleading, say on your Facebook page, and you let it sit there for months and you don't do anything about it, then you, in a sense, become a party to the misleading and deceptive conduct. You become a sort of a knowing publisher of it yourself, once it's been there for a long time and you've known about it. So I think that's probably the way to look at it, is, and so it therefore all comes back to that idea of monitoring and dealing with the inappropriate content as it arises. So I'm going to wrap up the proceedings now, and as I said, James and we will be happy to stay around and answer a few more questions informally. But thank you very much, James, our special guest presenter, for coming along from SMK today. If anyone missed the mailing list sign-up sheet, then just feel free to let us know now or drop us a line later on. I hope we provided some useful pointers, so good luck out there in the world of social media.